Hello, I'm Dr. Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We are delighted that you're able to join us today for the second of our two-part PSYPACT roundtables. As a trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of our many benefits that our insureds receive through the Trust. Three of our advocates are with us today, Drs. Mark Martinez, Joe Scropo, and Liesl Bryant. In the interest of time, we've placed their bios on the slide. The CE earned from this PSYPACT roundtable can be used towards fulfilling PSYPACT's 3-hour CE requirement for your e-passport renewal. I hope you benefit immensely from this PSYPACT roundtable. Please join me in welcoming Drs. Bryant, Scropo, and Martinez. Thank you very much. It's all yours.
Great. Thanks, Jana, and welcome to all of you joining us. We are glad to be with you today for part two, where we are going to be focusing on risk management. The part one focused mostly on what are the facts of PSYPACT, how does it work. Today, we're going to be talking about, given those facts, what do we recommend in terms of risk management for those of you practicing under PSYPACT. I also want to just quickly note there is a lot of complexity to this. It's not very simple, so I'll be sort of clarifying as much as we can as we go through it. Also, because to sort of try to narrow down a little bit, we are going to focus mostly on practicing under the APIT on PSYPACT today. So we're not going to talk a lot today about practicing under the TAP. We're going to focus on interjurisdictional telepsychology under PSYPACT. And already, as you'll notice, I am referring to all the acronyms of PSYPACT. So if those are new to you, please do, as Janet mentioned, and check out the link in the chat box where all of the acronyms are explained. So that being said, I'm going to go ahead and dive in. We do, as normal, we're starting with several questions, sort of that we got lots of questions on, and then we'll start taking your live questions after that. So go ahead and feel free to type in your live questions as soon as you want. I also want to clarify, so for those first 4 questions that we're going to start with, we're going to have one specific example, case example, because I think it's helpful to concretize a lot of this. So it'll be the same example for each question. And that example is, so let's say, Mark and Joe, here's the example. So the context, let's say that I, the clinician, am licensed in New Hampshire. Okay, New Hampshire is a PSYPACT state, so I'm licensed in New Hampshire. I have my APIT under PSYPACT, so I'm practicing under PSYPACT, and I have declared New Hampshire as my home state, okay? In my practice, my telepsychology practice under PSYPACT, I see patients in my home state, and I also see patients in 3 other PSYPACT member states. So for the sake of this example, we'll say Colorado, Texas, and New Jersey. Okay, so basically I'm practicing in 4 states, including my home state. Now, let's say that I, the clinician, travel to California, and I'm going to be in California for 1 month. And while I'm there, I get a call from my patient in New Jersey who is suicidal. Okay, now to clarify, I am not in my home state, so technically I cannot practice legally under PSYPACT anymore. New Jersey is a state in which I'm not licensed, where my client is, and also is a state that does not allow temporary telepsychological practice. So in this case, and Mark, I'll put this to you first, what do I need to think about in this, to consider from a risk management perspective in this case?
Yeah. So clearly there are a lot of moving parts in this situation. So what I will often recommend is that we break these down in some different categories where we consider different domains. Where I typically begin is the regulatory. Now, PSYPACT in and of itself is really intended to guide some of these regulatory issues. But as Liesl said, this situation, California is not a PSYPACT state. It's not a state where this individual is licensed. And so this would be outside of PSYPACT. And in that situation, what we want to keep in mind is where we are practicing as well as where we're practicing into. And in this case, New Jersey is a state where the psychologist is not licensed. So in order for them to practice in New Jersey, if they were to do so, that would technically be considered illegal, unlicensed practice into New Jersey. which may expose them to risk. And ultimately, if that led to some negative action, our professional liability insurance may not cover that type of practice. So if this is a crisis and we're looking at the regulatory issue and there's really no way to check that box and satisfy the ability to practice in New Jersey on a temporary basis, then what we want to focus on if we're making this decision is going to be the clinical and ethical domains as well. Now, crisis, I'd want to clarify what type of crisis is this? Is this something that we've been working on where the patient could be reminded to engage a safety plan that we've put together? Or is this something that goes above and beyond that we would really need to step in, and there may be not just a clinical reason, but an ethical mandate, or we may interpret it that way as an obligation to provide support to this patient for ongoing care, continuity of care, and to ensure that their welfare is put first and primary. So ultimately, what we're looking at is if we can't check that regulatory box, we want to have a very sound rationale for why we're going to practice into another jurisdiction if we can't do so legally, because that's going to ultimately, hopefully, mitigate our exposure to risk, explain what we did and why, as well as the alternatives that we did not take and why we did so.
Right, great. Thank you, Mark. Joe, do you want to add anything there?
Yeah, I want to add that the real issue in that scenario is that the PSYPACT holder is not in their home state. This rule under PSYPACT is that as a PSYPACT holder, you must at all times identify your home state. And you can identify, you can change your home state, but whatever it is at the time of delivering the service, you need to be in your home state as declared to PSYPACT. So in the example here, the clinician is in California, which is not a state where they're licensed and is not a PSYPACT state. So in order for them to treat a patient in New Jersey, which they could normally do if they were in their home state, which is New Hampshire. So home state, New Hampshire, New Jersey, PSYPACT state, practice is fine across from New Hampshire to New Jersey. The problem happens when the clinician leaves New Hampshire and goes to a state that is not their declared home state. At that point, they cannot practice under PSYPACT under any circumstance. They're not in their home state. So the problem is, how can they treat that patient in New Jersey? Really, the only available option might be a temporary permit or temporary waiver in New Jersey. But as Liesl said, New Jersey in this case doesn't have one. So this is a real bind for the psychologist, that if they do call that patient in New Jersey from California, they're essentially practicing without PSYPACT clearance and no temporary practice waiver from New Jersey. So that technically is illegal. There is no mechanism to make it kosher. And the dilemma happens when a patient is in crisis and we're now faced with, I break the law, or I violate the terms of PSYPACT, or do I help my patient? And although PSYPACT is a really honorable venture and something that's really desperately needed for us to be able to practice across jurisdictions these days, it does have its limitations, and it's in an early stage of evolution. So this is one of the issues that is hopefully might be able to be changed maybe at some point, but as of now, that the clinician in this scenario is in a real bind as to what they can do. So what should they do? It's the lesser of two evils, perhaps, as to call the patient, keep it short, make it very brief, make sure that only patients who have true emergencies will try to contact you when you're away out of your home state. There's some other mechanisms that you could try, but that's the fundamental dilemma here.
Yeah, I think you explicated that well, Joe, because to sort of clarify here, if let's say in this example, for instance, that my emergency patient had been in Colorado. Colorado does have a temporary practice law that would allow me to practice there for up to 20 days, so long as I tell the patient I'm not licensed there. So in that case, as both of you have said, I could call the patient and be covered under the temporary practice law. Part of the bind here, right, is that New Jersey doesn't have that. So I want to just sort of underscore a couple of things you guys have said. One is that, you know, in this case, if there is no, if you can't practice under PSYPACT and there's no temporary practice law, then the issue is practicing illegally. And I think, Mark, you said some of the best recommendation. Of course, you want to document your rationale. Joe, you also mentioned keeping it very, very short. I think you both mentioned that it should be a quote unquote true emergency rather than just, I don't know what we'd call, you know, a patient who just wants to talk to you or something, but an actual real emergency. And the other thing I'll mention is that we may, as clinicians, want to start thinking about having clear backups in these states that we're working in. That's another option, is you know, creating a system of other clinicians who can provide those kinds of services when we ourselves are not in our home state, so that we can't do that. Okay, I imagine there's quite a number of questions coming in about that, but I do want to go on to our second one. And again, this is the same scenario. We're going to use the same state. So I'm licensed in New Hampshire. I'm practicing under my APIT. New Hampshire is my declared home state. I now am seeing let's say I'm seeing that patient in Texas, right? One of the 3 PSYPACT member states where I have patients. One is Texas. This patient tells me, this patient has a history of assaultive behavior, and he comes into session one day and tells me that he intends to kill his boss, who fired him the day before. It's my clinical opinion that this patient does in fact have the means to do that, and I believe the threat to be imminent. So, and clearly there's an identifiable victim. So in New Hampshire, under my New Hampshire law, that would require me to act under New Hampshire's duty to protect law. However, Texas, where my patient is, does not have such a duty to protect law. So which state law should I follow, and what should I do to mitigate risk here? And Joe, we'll start with you on this one.
Well, the general principle is that under PSYPACT, that it's necessary to follow the laws in the receiving state. This is the state where the patient is at. In this example, the patient is in Texas, therapist is in New Hampshire. PSYPACT says that we follow all the laws in the receiving state, Texas, that pertain to patient health and safety. We'll maybe touch on this a little bit because that's not the clearest definition of which laws apply. But as a general rule, you want to operate under the laws in the receiving state, the patient state. So since Texas doesn't have a Tarasoff law, you as the New Hampshire therapist practicing in Texas would follow the Texas law. And that means that the Tarasoff, the ability to breach, to give warning, would not be available to you, or would not be as safe as it would be in New Hampshire. So that's just to illustrate that there are conflicts or differences between laws. And under PSYPACT, once you begin to practice in different states, it's going to be necessary for you to know pretty much all the relevant laws that pertain to psychology in that other state so that you can stay out of trouble.
Mm-hmm. Thank you, Joe. Mark, any additions there?
Yeah, I think it's just important to reiterate that documentation is going to be important, acknowledging that there may be 2 different standards, but while operating under PSYPACT, the expectation is that you're going to be doing so by the rules, laws, and regulations of the receiving state. In this case, in this example, Texas.
Right. So in a way, part of what I hear you say is that we're going to rely, as we always do, on our sort of traditional risk management strategies, right? Document, maybe consult. And Joe, you're also mentioning, both of you actually are mentioning that, especially under PSYPACT, really anytime we practice cross-jurisdictionally, but very clearly under PSYPACT, we are required to know the laws of that state. And as you said, Joe, to be practicing under them. So, and I want to just sort of, oh, I'm sorry, Joe, were you going to add something there?
No, I was just saying that's right. That's correct.
Yeah. And, you know, if this were in reverse, let's quickly say I'm a Texas clinician and I'm practicing into New Hampshire, right? New Hampshire has a very odd duty to protect clause that says that practitioners also have to potentially, you know, discharge that duty if there's a threat to property, literally. So it's a very odd thing. Most states don't have that. But that's an example, I think, of where a clinician who's not familiar with New Hampshire law wouldn't know that, because it's an odd law as compared to other states, and therefore may not know that they actually would have a duty to protect if someone was threatening substantial property and not a person. So it's just, again, we're switching our example there, but an example of how important it will be to really know the laws of the state into which you are practicing. Okay, Mark, next question for you. As you know, PSYPACT rules require us, we just talked about this, to be in compliance with the receiving state or distant state, if you're practicing under the TAP, but focusing on the APIT, receiving state laws. Now, speaking specific to informed consent here, because there's many questions we could ask about the laws, but I want to focus in for just a minute on informed consent specifically. Can you talk about what this means for clinicians practicing in other states with regard to informed consent issues and what your recommendations would be?
Yeah, so when you're practicing under PSYPACT, in this case, we've been focusing on the APIT, you're going to need to do some legwork in order to get up to speed with what rules, laws, and regulations are going to apply to you as a psychologist practicing into that jurisdiction. I think as a just as kind of a safe approach would be to go through the same process of informing yourself about these issues as you would if you were getting a license in another state. Many states have a jurisprudence exam, and you are expected to have fairly working knowledge of some of the basics and at least know where to look if you have questions about, say, mandated reporting, if there are record keeping requirements in your jurisdiction, access to records and things of that nature. So I would go through the same process to try to learn those things and incorporate those points into the informed consent. And so broadly speaking, you would want to include mandated reporting obligations, clearly specify those, record retention obligations. And in order to find this information, it can be a little bit overwhelming. I think, especially as you start adding in more and more jurisdictions, that's a lot of information to take in. And so as you're going through this process, a few resources that may be particularly helpful. If you go to the PSYPACT website, there are some state resources, the websites related to different state licensing bodies that will provide a summary of their rules, laws, and regulations. You can also just go directly to state licensing board sites. Some of them are easier to navigate than others. And some of them have FAQs that can really help guide this type of information collection. There's also Epstein, Becker, and Green. They have a telemental health laws app that you can download on your phone, and you can navigate some of these important laws so you can become more familiar with them. There are also ethics committees or state psychological associations that have a wealth of information on their website, and often leadership or those associated with state psychological associations can point you in the right direction for resources as well. Also, the trust risk management consultation service, if you contact us, there are a lot of ways that we can go about trying to assist you and finding this information and directing you towards additional resources. And of course, while a costly option, it's still a great option to consult with local legal counsel in the jurisdiction in which you're practicing, especially once you've crafted a document, to get them to look over it and make sure that it's comprehensive and that it is, to at least confirm that it is applicable in that jurisdiction.
Great. Those are a lot of very good tips there, Mark. Joe, anything to add?
Just that it can be daunting to do. So I would go slowly. And if you have doubts, use some of the mechanisms that Mark was talking about. You can call us and we can try to help you locate the relevant law in the receiving state. You could even call the board in that other state and ask where you can find the relevant section that will guide you on your particular question. So it's going to require being creative to try to find different ways that you can get the information you need to safely practice.
Yeah, and I think too, it may be this may be one reason to not jump into practicing in 15 or 20 states all at once, right? You may want to take on 1 or 2 states, take the time to really learn those laws, and then maybe add another if you decide to. But I think it's going to be harder if you're practicing in, now there's 40 fully states that are member states. So if you're practicing in many, many states, you're going to have a lot more work to do in this regard. So. Okay, Joe, last question to you before we start to dive into the live Q&A. And again, let's go back to that original scenario. My home state is New Hampshire. And let's say that one of my patients in Colorado, which is a PSYPACT member state, my Colorado patient files a board complaint against me. Now, we know the board complaint process is a little bit different in some ways under PSYPACT. So can you speak to sort of how that would play out, the board complaint process, and what are some of the things I, as a clinician, would need to be thinking about from a risk management perspective?
Okay, this is one of the more confusing, I find, or convoluted parts here under PSYPACT, that if one of the rules, it's just a rule in PSYPACT, that if you receive a complaint, you cannot change your home state. So you must stay in the home state that you received, that where you were at the time the complaint was filed. The reason for that is PSYPACT wants to make sure that all PSYPACT psychologists are subject to discipline, or at least can be disciplined. And they want you to be in your state, your home state where you're licensed, because that's the board that can discipline you. So in order to prevent you from evading being disciplined or investigated, PSYPACT locks you in once you've received a board complaint into your home state, and you can't change it. And that has implications if your part of your regular practice is to change home states, depending if you're traveling or you have multiple offices. You won't be able to do that once a board complaint has been filed. Then the process of adjudication of the board complaint is also somewhat unusual. The laws that apply to deciding whether you have violated a licensing law are the laws of the receiving state, the state where the patient is at. Yet under PSYPACT, the investigative entity that looks into your specific conduct is your board. So it's a kind of an odd situation, and we'll have to see how this plays out. But your home board is going to somehow have to know what the laws and rules are in the receiving state and use them to try to adjudicate you in your home state. So that we have to see how that's going to play out. That's going to be a difficult task, I think, for everybody involved. The other possibility is that you may not receive a board complaint, but let's say the receiving state where the patient is somehow doesn't like what you're doing, and it issues a injunction or some other order to get you to cease. That is going to require you to immediately stop, and it's viewed under PSYPACT as an adverse action against your license, which means that it automatically removes you from PSYPACT. PSYPACT will not allow any of its members or users to have a sustained adverse action. And so in their thinking, if the receiving state issues an injunction, that's deemed to be a substantiated adverse action, and you would lose the ability to practice, which could be very serious if you're in the middle of treating a lot of patients and suddenly it's gone.
Yeah, thank you, Joe. I know, and I will say, I know there's a lot of information here, so we'll try to keep repeating it because I think you said many, many very important points. Mark, do you want to add anything there?
Yeah, I think one of the things to keep in mind is if an adverse action is to occur, And so they define it as any action taken by licensing authority that shows a violation of a statute or regulation. And it's a matter of public record. So as Joe mentioned, an injunction, that is going to be indefinite. So you'll no longer be able to practice under PSYPACT. And that will not be something that you could petition, say, in a year or two down the road. That would be indefinite. The other issue is, I think from a risk management perspective, if you are switching home states, which you can do fairly easily, if you were licensed in more than one of the compact states, but let's say you only spend a short period of time, you're licensed in, let's say, New Hampshire and North Carolina, both PSYPACT states, and while you're in North Carolina, you tend to be there only maybe for a week or two, but you decide to switch your home state and see people under PSYPACT while you're there through telepsychology. And then there was some type of complaint issued. If you were to return to New Hampshire, you would not be able to then switch your home state back to New Hampshire while that investigation is ongoing. And so if you have many patients in different jurisdictions under PSYPACT, that we're going to be back in the same place where we were in our first couple scenarios, where you'd have to be looking at temporary practice allowances or states where you are licensed, and then weigh that against the ethics and the clinical aspects of the case, because you may be exposed to some additional risk there.
Yeah, and yeah, that's an excellent point. So just to highlight a couple of things that you guys have both said now. One is that if you get, or if and when you get a licensing complaint under PSYPACT, you can no longer change your home state. You are locked into whichever home state was listed as your home state at the time the complaint was made. So that may impact your travel and may impact your ability to treat patients. Also, I think, Joe, you said that it is, if and when you get a complaint, you will be judged on the basis of the receiving state law, not on the law in your home state. And I think that's really important to keep in mind. And then you both have mentioned if you get either a fine, a formal board complaint, like a finding, that you've done something wrong, or even if you don't do that, but you just get, say, a cease and desist order, Joe, as you mentioned, from that receiving state, that is considered an encumbrance on your license under PSYPACT, and you are permanently disallowed from practicing under PSYPACT. If you get any kind of encumbrance or a board complaint that is founded, you can no longer practice under PSYPACT, period. There's no way to get that back. So again, I think these are just things to really think through. And you guys have mentioned some of the ways to manage that, or at least be thinking about that. Okay, so let's dive into now the some of the live questions. The one here at the very beginning, is Canada included under PSYPACT? No, this is just the US, so we're not going to spend much time on that, but the answer is no. I also want to note there's some questions here about filing insurance claims under APIT. I'm gonna skip that for today because I think that's a little too far afield from what we're mostly focusing on. Yes, there are some issues with that, but maybe we'll try to address that in another webinar. So, okay, here's a question too. We get this a lot. It has to do with, what if you did not come from an APA accredited program? Can you get your APIT and or TAP under PSYPACT? And will that change at any point? So Mark, maybe I'll start with you on that one.
Yeah, I believe that you have to, and I have to go back through the rules here, so remind me, but I do believe you need to have an accredited program, or be able to demonstrate that the program was similar in terms of its substance. Is that an option, or is it strictly APA accredited? I can't recall right at this moment.
I think it's strictly APA accredited. We can double check on that, but because I know there's been a lot of issues with that. Some people have been upset about that, but as of now, I believe it's only, you have to have APA accreditation. Yeah. And I'm not aware that will change. Joe, are you aware of anything there?
No, I'm not. And that is a sticking point for people who didn't graduate from an APA approved site or program. But that's the rules, and maybe it'll change, but that's how it stands now.
Okay. All right, so here's another question. We're getting into some specific states here, but the issue is I'm licensed in Illinois and Kansas. I believe both of those are PSYPACT states, but I don't have the map up here in front of me, so please tell me if I'm wrong. If Illinois is my home state and I am temporarily in Kansas, again, these are both PSYPACT states, can I see a client in another PSYPACT state, or do I have to change my home state temporarily? Joe?
You're going to have to change your home state. You always need to be in what's identified as your home state to work under PSYPACT. But the good thing is that you can change your PSYPACT home state. It's not that difficult. You log into their website. I haven't done this, but this is what I understand. And there's like a little toggle, and you can just identify a different state as your home state. Although you have to be licensed in that state, and you also need, that state also needs to be part of PSYPACT. So as long as those two conditions are met, you can toggle back and forth, or if you have three, you can just change it and then you easily on the computer, go to that other state and then practice under PSYPACT, and everything's, that's all part of the rules. You're okay.
Yeah, I think the key thing is you're saying is you've got to get if you're traveling a lot under PSYPACT, you have to get very good at remembering to change your home state. Because to be clear, if you don't change your home state, right? So let's say in this example, Illinois and Kansas, and they travel into the other state, but they still have Illinois declared their home state, and now you are in Kansas practicing, that is considered illegal under PSYPACT. So if you had an issue come up in that instance, you would not be considered legally practicing. So if you are in a different home state and you forget to change your home state declaration, that would be considered illegal practice. So all the more important that you've got to get used to doing that sort of toggling. So I'm going to jump into the next question because it's a little related and hopefully will allow for some more clarification. So this is the issue. If you live in a border city and you have licenses in both the border states, can you set aside the APIT in order to provide telehealth under just your license? This can be useful if you travel in between both states in the same day to practice, or if you have a practicum student intern and they practice telehealth under your license, but cannot allow the student to do that under APIT. We have a lot of issues in this one question. Mark, do you want to take an initial stab at it, and then we'll...
So in this situation, is the person licensed in both jurisdictions of these border cities, in both states?
They don't clarify, but I believe that's what they're getting at, that they are licensed in both.
Yeah, so in this case, my understanding is that you could practice under your license outside of PSYPACT in order to provide services. But I think it'd be important to also to document. I think because at this point, there are some options available. And so if you are operating under PSYPACT, there are going to be some rules that you're going to have to attend by. The home state declaration, for one, you're doing telepsychology. If you're outside or say PSYPACT's not available and you're looking at temporary practice allowances in a jurisdiction, if they have it or not, or if you're fully licensed, I think it's important to be very clear on which one of these pathways you're taking, not just for yourself, but also to document so that you can understand exactly how to proceed. But in this case, if you're licensed in both jurisdictions, then PSYPACT, you can practice in that way just as you would being fully licensed in those jurisdictions outside of PSYPACT. But I think you'd want to document that.
Mm-hmm. Joe?
Yeah, I think it's important to start every note because there are these two parallel methods of providing service. Potentially, one would be PSYPACT, and the other would be a temporary practice provision in another state. They're two separate mechanisms, and they don't overlap. So if they're both available to you, you need to identify which one you're working under in your note each time that you make contact, because many of the temporary practice laws only give a limited amount of time, or they require some other procedures to be carried out in order to earn that temporary practice privilege. So unless you identify clearly in each session which one you're practicing under, it could lead to a lot of confusion. So if you have both options available for a particular patient, you should make clear for each session which system, PSYPACT or temporary provision that you're working under.
Yeah, I agree. I think the documentation is going to be key. And I want to just point out a couple of quick things too. One, the question here said that you can do that practice under a temporary law so that your intern can see patients, your supervisee can see patients. That may not be the case. Even temporary laws may not allow your supervisee to practice into another jurisdiction. So that's a little bit far afield from where we are today, but I want to just make that really clear. I think the other thing that's important is both of you have mentioned these temporary practice laws, but it's very important to realize that temporary practice laws vary per state. If you remember our original example here today, New Jersey does not allow, like I couldn't practice into that. They don't allow outside state practitioners to provide telehealth into New Jersey under a temporary practice law, whereas Colorado does. Texas will, but they have a lot of requirements, 30 days advance notice. You have to pay an application fee. You have to have a supervisor on the ground in Texas. So if you are practicing under a temporary law, as both Mark and Joe have said, yes, document that that's what you're doing, but you also have to be sure that you're in compliance with that temporary law for that specific state. So just wanted to clarify that as well. Okay. Okay, here's another question on supervision. So a practitioner is licensed and working under APIT and supervises a licensed psychologist in Virginia state. The supervisee wants to see clients in Hawaii, which is also a PSYPACT state. Is the supervisee able to do this under the supervising psychologist's APIT? I'm not sure which one of you was next, so Mark, I'll just give that one to you.
Yeah, so this is a fairly new rule. So under APIT, and just looking here, it's 4.13, where the authorization to issue by PSYPACT APIT applies only to the specific individual, the authorization holder. It cannot be used for, say, a supervisee in this example to see patients in other PSYPACT states. So under this situation, that would not be permitted.
Yeah, that's correct. And just to clarify, I'm not sure it's new. I think that's always been the case under PSYPACT. It's just that they recently sort of put additional language to clarify that. Yeah. Joe, anything you wanted to add there?
No, I don't think so, except I got the impression that it was a licensed person in the other state, but perhaps not. But it doesn't really matter. Whoever
No,
that.
it's a trainee. I'm sorry, Joe, just to interrupt. It's a trainee who's working under the license of this Virginia psychologist. So it's a non-licensed trainee working under the supervision and under the license of the Virginia psychologist.
Right. So the answer would be the same. PSYPACT apparently does allow you to supervise through PSYPACT. In other words, if you have PSYPACT and you're supervising someone in another PSYPACT state, as long as everything else is okay with doing that, PSYPACT doesn't have an issue with you delivering supervision, but you can't have your supervisor, your supervisee, use your credential to practice under PSYPACT.
Correct. Great. Okay, so here's one. It's a little bit complex, but we'll break it down. So here's the question. Am I obligated as a licensee in a state that does not prohibit these things to follow restrictive rules in other states that conflict with my personal and professional ethics? So the question here, that is, they say, if I'm seeing someone through PSYPACT in a state that has recently passed laws that outlaw transgender care or abortion, can their licensing board go after my license if I work with a trans person in that state and provide them with gender affirming psychological care? Joe?
No, you can't. The laws in the receiving state control. anything that has to do with patient health or safety, which I suspect this would likely be defined as such in states that prohibit. I guess this is more of a hypothetical, but in the hypothetical, if that receiving state does forbid gender affirming care, you must obey the laws in that receiving state. You can't do it. You can't engage in gender affirming care. So that would be that.
Yes. And I think this is a great example of really needing to know the law in another state. You have to really know that. You'd have to, you want, again, to be documenting and consulting. But the last question there, could that receiving state licensing board come after your license for doing that? Absolutely, they could. If the receiving state thought you were in non-compliance with their laws, they absolutely can come after your license. Mark, anything to add before we take another question?
Well, I think that becoming familiar with these rules, laws, and regulations ahead of time is especially important. And the hypothetical had mentioned if there were ethical, moral stances that were contrary to these, then that may indicate that you may not want to take cases in those states, or if it's going to run contrary. Because if you are going to act, as Joe pointed out, and not be in line with those laws, then you could face an adverse action for not being compliant.
Right. And I will take this opportunity to also remind people, I think one of the reasons why this matters sort of more in terms of its consequence is that if and when you get a founded board complaint, or not even a board complaint, it could just be a cease and desist letter from another board in, say, the receiving state. If you get a cease and desist and or found a board complaint, you permanently lose your ability to practice under PSYPACT. So that, of course, then would carry weight for all of your clients in all PSYPACT states. So I think when you're making decisions about which states you're going to practice into and how risky of a practice you will have in different states, you have to keep in mind that all of your patient practices may come sort of get impacted by that. Okay, so here's another case. My patient moved to Texas from Missouri. She will not seek a new therapist and wants to see me in virtual sessions. This is not necessarily PSYPACT specific, but the question is, should I just drop her? So what do we do with patients who move to another state where maybe we're not licensed and that patient refuses to get care there and says they will only see us? Should we drop them? This writer writes in and says that does not seem ethical to me. So Joe, how would you recommend clinicians think about this from a risk management perspective?
So one thing to do is to build into your informed consent warning about this, that if the patient is to relocate to a place that you don't have regulatory clearance to practice, that you won't be able to see them. So I think warning your patients through good informed consent is step number one. Now, if the person moves to a state that has temporary practice privileges and you can arrange for those, you can treat that patient for some period of time. As Liesl said, the rules vary drastically from state to state for temporary practice. So, but assuming that there is one where your patient has moved to, you may be able to use that to at least transition them to somebody else in that state. But once that exemption has disappeared, assuming it existed in the first place, you would be practicing illegally at that point by continuing to treat them in this new state where you're not licensed.
Mm-hmm. Yes. Mark, any additions to that?
I think ideally, when you are discontinuing treatments, that's going to be, if that's what this comes to, and it seems like that may be a direction that you'd have to consider, if not take. Under ideal circumstances, you would inform the patients, you would discuss your clinical impressions and recommendations you have moving forward for them, the risks of them not complying with those recommendations, and then provide referrals and try to facilitate the transfer of care, assuming you think ongoing care would be indicated. So in this case, taking that time, if there is a temporary practice allowance available, to carry that out if you can't practice into that jurisdiction legally after it's exhausted, or even prior to, you can put that information into writing if you can't have closing sessions, and provide that information to the patient to try to facilitate ongoing care and give them something tangible moving forward.
Yeah, and I mean, in some ways, I think, you both have pointed out the temporary practice laws, and that might be useful for allowing those sort of pre-termination sessions or sort of as bridge sessions. But I do think, and tell me if you guys, either of you disagree with this, but if a patient permanently moves to another state, even the temporary practice law is only going to cover you for a short term. So I think if a patient really moves and you want to provide long-term ongoing care, I think you have to get fully licensed there, or you have to be practicing under PSYPACT, because all temporary statutes are going to run out. But Joe or Mark?
It depends. I mean, sometimes college students go to college out of state from where your home state, and if California, for example, typically gives 30 days in a calendar year as a temporary practice provision. And it may be possible to space those out such that you could see the person and then they would return home. But as a general rule, unless you know that they're going to be there for a time less than the maximum temporary practice allows, you're going to have to start discussing, as you're doing this, what's going to happen when the waiver ends. You have to be planning with the patient and not doing it in the last temporary practice approved session. So you want to make sure you keep that in mind. We're getting up near the limit, and we need to work out a plan for you at that point. Yes.
Yeah, great. So this is circling back to the issue of informed consent. And the question is, I heard you all say that we need to have a different informed consent for every state we practice in and address any jurisdictional laws in our informed consent. Is that the case? And then a follow-up question, could we have a more general informed consent saying, quote, I will abide by the confidentiality laws in the state where you are located? Joe, do you want to jump in on that one?
Yeah, I don't know if you need, I mean, I don't know if you really need a truly completely separate one for every state. I think a lot of the informed consent concepts cross over states. What are the risks and benefits of psychotherapy? What to do if I'm not available? Ensuring there are a lot of things that probably cut across. I imagine the most important ones have to do with breaching of confidentiality, because that's what people generally are really concerned about, is someone else finding out about them being in treatment and involuntarily losing that confidentiality. So that may be a place that you want to be more specific in. But unfortunately, states have very odd nuances in their licensing law sometimes that dictate how and when informed consent must be given. So there's no real substitute for looking and seeing what that state says. So it would be wise to check if there is any special unusual provision, number one. Number two, to cover and focus mostly on times of breach when you would have to breach the patient's confidentiality. Say those are the two areas that you mainly want to tailor to those states.
Mark, any additions?
Just that because of those unique aspects, I'm a proponent of having those documents that are drafted reviewed by a local counsel, because sometimes, as much as research you put into discovering these and trying to make sure that you're looking at confidentiality limitations or record requirements in that jurisdiction, there may be something you miss. And so as a conservative approach, that's something that I would recommend. And I understand that is an out-of-pocket expense. And if you're practicing in a lot of jurisdictions, that seems like a burden that you just may not be willing to take. But that also may argue toward not practicing into a large number of jurisdictions, at least all at once, so that perhaps you can make sure that these are really tight documents moving forward and covering all of the necessary bases.
Yeah, I agree. The other piece I'll add in there, because Joe, I know you mentioned the confidentiality. I think part of what's tricky, as you said, is that different states have different laws. And so my understanding under PSYPACT is that, we're also held to the receiving state's record releasing laws. And different states have different laws about whether you do or don't release records under certain circumstances, whether you can or can't withhold in certain circumstances. There are different rules, as you know, about how should I release or when should I release like testing data. Different states have different laws about that. So my understanding is we are still held to those when we're practicing under PSYPACT. So I think this is what's hard. And Mark, that's where I like your recommendation, craft as much as you can under your understanding, and then get a local attorney to sort of review it and make sure that it's in sort of it's compliant with all laws of that state that you're practicing into. Okay, so we're getting close. Let's see. So here's a question, not exactly PSYPACT, but I think it's worth mentioning here because there are some distinctions between practicing under PSYPACT and practicing, say, outside of PSYPACT. So this question is, without PSYPACT's APIT, can a licensed clinician in one state treat a person in another state where they are also licensed? So it is crossing state jurisdictions, but the clinician is licensed in both states. Or in essence, is that a reason that you should apply for the APIT? Do you have to have your APIT in that circumstance? Joe, do you want to jump in on that?
Yeah, so if I sure I understood the question. Could you just repeat it, Liesl?
Yeah, sure. So let's say that I'm licensed in both New Hampshire and in Maine. So I'm licensed in both states. Do I have to have my APIT to see patients in Maine, assuming I'm in New Hampshire, or can I practice under just a licensure there, or do I need to apply to APIT?
Okay, thanks. And I understand it now. Yeah, you can always practice under your license into your jurisdiction, but it depends on your risk threshold as to whether you want to check with the state that you're physically in when you're practicing back into your license state. So you're at, let's say, Indiana on vacation, you're not using PSYPACT, you're going to practice back into your home state, you're licensed there, your patient is there. My understanding is that most states don't have an issue with that, but you're also physically located in a place that you may want to check with the board in that jurisdiction. Again, it's a function of your risk threshold. In theory, that other board, Indiana, in my example, where you're just standing and calling into your licensed state, probably doesn't have any interest in what you do with your patient in your licensed state. But if you really want to cross your T's and dot your I's, you may want to call and check with the board to see if that's the case, whether they have any objection to you doing that, just using their physical space, their state, as your base while you're calling and doing therapy somewhere else. I suspect generally not, but the only way to know for sure is to call the board in that state.